Are you sure?
Here's the 30-second lesson on what legends know. Never ask a bride why she's getting married. Don't wear a skirt on a windy day. Deodorant is not a shower. Don't sniff chili flakes. And don't forget, saving is not investing. Legends don't just save, they invest in mutual funds. Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
One bit of litigation, personal litigation, between two individuals came to a head in 1985, almost 4 decades ago. In fact, exactly 39 years ago. That, besides the fact that it made a big difference to the individuals involved, it also turned into India's politics inside out and upside down. How it happened, I will explain to you as we go along. I will just tell you that this was called the Shah Bano case. The judgment was delivered in that case in 1985 by a Supreme Court bench headed by then Chief Justice Y.V. Chandrachud. Right? It was one of his landmark judgments. In that judgment, the court said that Shah Bano, the 73-year-old woman from Indore then, who was married to a prosperous lawyer, Mohammad Ahmad Khan, in 1932. She was entitled to an alimony besides whatever limited dower or meher she might have had, because that amount may not have been adequate in 1975 when she got divorced, given the fact that this was pledged to her in 1932. Nobody makes these things inflation linked, right? So she wanted an alimony. The Supreme Court approved an alimony. This went through the legal system. Supreme Court approved an alimony of just 500 rupees a month for her. That caused a political storm, which I will tell you a bit more about as we go along, as I said, because that's a story I covered. It was a cover story in India Today in the Jan 31, 1986 issue. Now, that story turned politics inside out, upside down, as we just said. That in a way has found closure today. Now, do such things ever find closure? I don't know, because these things are a mix of social issues, religion and politics. All of it gets mixed together. It's quite a complicating, deadly mix. So maybe these things never find a conclusion, but to the extent that each step brings you closer to a conclusion, this judgment has today come from the two-judge bench of the Supreme Court of India. The two judges are Justice B.V. Nagaratna and Justice Augustine George Massey. So the two have given differing orders, differing reasonings, but arrived at the same conclusion. In effect, it turns the clock back again on a process whereby Rajiv Gandhi had turned the clock back on the Supreme Court judgment of 1985. After the Supreme Court judgment of 1985, because there had been a lot of protest from the Muslim community, particularly the Muslim ulema, and also Muslims in the Congress party, and it was seen as if it was feared by the Congress party that this would lead to a loss of Muslim vote for them, Rajiv Gandhi had passed a law. This was a law passed in 1986 called Muslim Women's Protection of Rights on Divorce Act of 1986. That effectively set aside the Supreme Court order giving alimony to Shah Bano. This law now said that a Muslim woman is only entitled to what she is entitled to under the Muslim marriage laws or Muslim personal laws, which means whatever was committed to her by way of meher or dower at the time of the marriage. And also there are some other covenants as well. For example, there is some maintenance to be paid in the period of what is called as iddat. That is the period for which she is not allowed to remarry. That's usually about 3 months after her divorce. In case of the husband's death, it can be 4 months. These things are complicated, so I'm not going into all the details of that. But that iddat period is a short one. So there is some maintenance given through that iddat period. After that, she's basically got what was committed to her at the time of marriage, because Muslim marriage was seen to be as a contract, not as a sacrament. So Rajiv Gandhi passed that law. What has today's order done? Today's order, it's a 99-page judgment. It's also 99 pages because the two judges have given their own reasoning and they've come from different routes. They've taken different routes and arrived at the same conclusion. So what I have with me is about 3 and 4 pages of the joint order, which is distilled from the two streams of reasoning. So one, Justice B.V. Nagaratna has approached this more from the point of view of women's rights, a woman's agency, a woman's financial freedom, independence, etc. Whereas Justice Masih has come more in terms of the interpretation of the law and what the Supreme Court has said so far and the other courts have said so far. And the fact he's also highlighted why this judgment has become necessary, that's because in the course of these decades, different high courts have been giving contradictory and different judgments. This case, for example, on which the judgment was delivered today, this came into being. This became a case because the gentleman called Muhammad Abdul Samad, he went to court. He went to court because his wife went to a trial court and sought remedy under Section 125 of CrPC, Code of Criminal Procedure. Because it's Code of Criminal Procedure, it brings in the urgency of a criminal law to an issue. So any woman of any faith to get her rights ensured, to get maintenance, if she feels denied that right by her husband, particularly in the case of a divorce, then she can take resort to this section of CrPC. So in this section of CrPC, Muhammad Abdul Samad's wife went to court. So the trial court awarded her 20,000 rupees. Abdul Samad contested this. It went up to the High Court. The High Court reduced it to 10,000 rupees, but still maintained that she could get this alimony. Muhammad Abdul Samad's argument was that because of the 1986 Act, the act we just told you about, Muslim Women Protection of Rights on Divorce Act of 1986, or let me just say the ShahBano Act, which is sort of an ironical way of putting it, because that act was passed to deny what was Shah Bano's due as per a Supreme Court judgment. So Abdul Samad claimed that that act overrides Section 125 of CrPC. So the argument, once again, the same as the argument in the case of Shah Bano, which is that does a divorced Muslim woman have recourse to the normal secular laws of the land when she got married under her Muslim personal law, under her religious law? That, he said, that because a new law was passed, that overrides his ex-wife's rights as an Indian citizen. And the fact is, because the High Court did uphold her right, he felt constrained to come to Supreme Court of India. Now we know in these cases, as we knew in the ShahBano case, I covered that case in granular detail. In these cases, activist lawyers get involved on either side because they also see each of these cases as a test for the law and also a case which will go to the highest court and help define or redefine the law. Right? And that's how this case came to Supreme Court as well. It was just over a 10,000 rupee alimony. So in fact, if the ShahBano case was about 500 rupees a month, this is about 10,000 rupees. If you apply the test of inflation, it's not that much more than 500 was in 1985. These are issues of principle, and that's why this order is important. So what have the judges said today? First hear that. The judges have said that the law that under Indian Constitution, every Indian, man, woman, any gender, and of any faith has the same rights. And that while Abdul Samad claimed that this is a special law, and the principle is that when a special law is enacted, it overrides the general law. The court said that they don't accept the argument that this law begins with the idea of notwithstanding anything else. They say this law does not rule out anything else, that any Indian citizen and any Muslim woman as well, like any other Indian citizen, has recourse to Section 125 of CrPC. So effectively what this means is, this does not mean either or. The choice lies with the woman. In this case, the married Muslim woman, a married, divorced Muslim woman, divorced, separated Muslim woman. She can take recourse to one law or the other. She can also take recourse to both the laws. So I will not read out the entire order to you. I will share a link with you of the entire judgment. You can read the judgment. Last 3 pages are the order. But basically what it means is, first of all, the woman can choose under which law she wants her maintenance, right? If she thinks her meher is good enough, that is all right. It's her choice. She can use the Islamic law, the Muslim personal law. If she thinks that is not good enough, she can also seek maintenance under 125 CrPC. In which case, if the husband wants to contest it, the husband has to prove 2 things. One, the husband has to first of all prove that he has fulfilled his obligations under the religious law, his own obligations at the time of nikah, under his own religious law, which is the payment of the dower, meher, etc., and the maintenance during iddat or whatever else it involves. The second thing he must prove is that she is capable of maintaining herself with what has already been given to her. She does not need more maintenance. She, on the other hand, will have to go and argue that no, what I have got is not good enough, or maybe after a couple of years I have run out of it, so I need more maintenance. Then she can take recourse to Section 125 CrPC, as a married woman of any faith can do in India. That is the essence of this order. Then, of course, a magistrate can rule on whether she is justified in seeking more money or not, but she has the legal right now to seek more money by way of maintenance under Section 125 CrPC. That was the nub of the Shah Bano problem. This was done. A similar argument was used by Justice Y.V. Chandrachud's bench in 1985. That was negated by the law that Rajiv Gandhi passed. That has, again, I'm giving you a very generalized statement that intellectual, legal, juristic, and political and moral, if you might want to add it, political, moral, religious argument has now been restored by the Supreme Court of India. That is the import of this order. So I will just read out to you the one really relevant para from this order. So here we go. If Muslim women are married and divorced under Muslim law, then Section 125 of the CrPC, as well as the provisions of the 1986 Act, which I told you we can sort of with a touch of irony call the ShahBano Act, both become applicable. That is, Section 125 of CrPC as well as the provisions of the 1986 Act are applicable. Option lies with the Muslim divorced women to seek remedy under either of the 2 laws or both laws. This is because the 1986 Act is not in derogation of Section 125 of the CrPC, but in addition to the said provision. That is where the Supreme Court order actually takes a big step forward. And this order has come because different high courts have been taking differing interpretations and also giving contradictory judgments. Further, this order goes on to say, if Section 125 of the CrPC is also resorted to by a divorced Muslim woman as per the definition under the 1986 Act, then any order passed under the provision of the 1986 Act shall also be taken into consideration under Section 127(3)(b) of the CrPC, that is, implementation of her claims under 125 CrPC. Then the court clarifies it further and says that, look, the husband might say that, see, she's already got so much from me in terms of her own rights and my commitments under my religious marriage laws. This is too much. So if that has been paid and magistrate comes to the conclusion that she's already been paid quite a bit and now she's going to get this maintenance, then what she's been paid already can be netted off against the further maintenance that she is going to be paid. So it's not simple, it's going to be a bit complicated still. It is not open and shut. There will still be arguments in some magistrates court. That possibility remains open. The possibility that's been closed now is, once again, the principled argument that a Muslim married woman, once divorced, has no recourse to the secular laws of the country. Now the legal part done, let me take you through a little bit of politics. When this judgment came in 1985, Rajiv Gandhi had just come into power in December 1984 with a majority of 415 in a house, initial house of 528 or something. So this was a humongous majority. But it looked like he had suddenly begun to lose the Muslim vote. So within a year of coming to power, he lost the by-election, his party lost the by-election in Kishanganj constituency of Bihar, which is a Muslim majority constituency and usually a Congress stronghold, because until then, there were no other claimants for the Muslim vote. So it looked to him and his party that they had lost that seat because of their inability or their disinclination to promise that they were going to enact a new law to set aside this Supreme Court judgment, because this had become a big emotional issue. That is the election in which former Ambassador Syed Shahabuddin, and by now a redoubtable, formidable Muslim personal law activist, he contested against the Congress candidate, and Congress candidate was not even directly from Congress but borrowed from Jamiyat ul Ulema-e-Hind. So Congress thought that they were putting up a clergyman there. In any case, they had won that seat by more than 1.30 lakh votes just less than a year earlier. So where is the problem? But that candidate lost in a big reversal and Syed Shahabuddin won. That was the first indication that Congress party had begun to lose the Muslim vote. And how did Syed Shahabuddin describe this? So I quote from my own story from that January 31 India Today issue, where Syed Shahabuddin said to me, and I quote, "The Humpty Dumpty of Congress I's vote banks," Congress was then called Congress I, "the Humpty Dumpty of Congress I's Muslim vote banks has come crashing down, and never again can all the king's horses and all the king's men put it back there again." Now the fact is that this was quite prophetic, because between 1985 and at least till 2000, this election in 2024, the Muslim vote bank did not come back to the Congress. 1989 onwards, 1989 election onwards, we had seen the Muslim vote leaving the Congress party. It went to Samajwadi party, it went to RJD in Bihar and Uttar Pradesh. Other parties began getting it in other places. The left began getting it in West Bengal. Although the left, remember the left, the CPM was the only party which took an overt and clear, a completely unambiguous position in favor of Shah Bano, right? But even then, Muslims were angry with the Congress party, and that is what really worried the Congress party. Again, in Assam, elections took place. In those elections, 18 seats were won by the United Minority Front. These were all seats in areas and constituencies which had a large Muslim vote and which the Congress would have taken for granted. Some other by-elections also, the Congress suffered, and that's how the panic set in. The panic set in also because there were big, massive Muslim protests. I would suggest, if you want more details, you can read that story of India Today's wonderful archives. I will share a link with you. You can go back and you will find many familiar faces. Of course, they are all 40 years younger than how you see them now. Najma Heptullah is there, Shahid Siddiqui is there, Arif Muhammad Khan. So many of them are there. Zoya Hassan, the scholar, they are all there. At that point, protests became so strong that in Mumbai city, it was called Bombay then, more than 500,000 Muslims came out in protest. This was almost like Islam was in danger. And I have some quotes also in that story. For example, there is a quote from Firoz Jahanara Begum, who was a school teacher in Kasganj in western Uttar Pradesh, who said, and I quote, "Once we are divorced and the man has met his obligations of meher, he becomes a gair." A gair means a stranger. A gair for us, we have to observe parda from him, and taking money from him is haram. We can't take money from him because वो पराया मर्द हो गया, वो गैर हो गया. He's become a stranger to us. There were other leaders at that point who you might have expected to have weighed in on the side of modernity or on the side of a liberal interpretation of religious laws. But they were not quite like that. Najma Heptullah in the Congress party, at that point, she said, and I quote from her, these are published quotes in that story. She said, "Muslim marriage is no sacrament, unlike Hindu marriage. Muslim marriage is no sacrament. There is no taking vows around the fire, no business of till death do us part, no kanyadan. husband's responsibility ends the moment the contract is terminated. So she said Muslim marriage is a contract, not a sacrament. Husband's responsibility ends the moment the contract is terminated by divorce after the payment of meher. And then she said, when I argued with her, that look, you are saying that the new law will put the onus of maintaining the divorced woman on her parents, on her brothers, on her sons. How fair is that? And she said, it's a published quote, tell me which relationship is more important, one that is purely contractual, that's marriage, one that is purely contractual, or the one of blood. Now the fact is that when Rajiv Gandhi passed this law actually did put the onus of the maintenance of a divorced Muslim woman if she thought that her settlement or her compensation from her husband wasn't good enough. They put that onus on her family, her own family, and if they fail to do it, then through a magistrate to the state Waqf board. In fact, that led to another woman leader in the Congress party speaking out in protest, and that one was Margaret Alba, who was then again a very young minister for youth and sports affairs, and she said, look, if you do this for Muslim women, why aren't you doing it for all the women of other faiths? So this is not fair. So this had divided the Congress party as well. Again, in the Congress party, there were also voices of liberalism. Congress parties at that point, the most promising young leader, Arif Muhammad Khan, spoke in favor of Shah Bano, and he said, look, the Prophet himself was very liberal and very progressive on women's rights, and religious laws, scriptures only give you broad direction. It is important for parliaments to continue to enact legislation to make it more specific. In this story, there is also an interview with Arif Muhammad Khan recorded in December 1985. I will also share a link of that interview with you. Please see that. From that interview, I just pick out one quote for you in this discussion. And Arif Muhammad Khan said, and I quote, religion is always taught in parables, and that is why it becomes imperative to supplement it with social legislation. And then he goes on to say the Prophet was extremely progressive on women's rights, and government can legislate from time to time on these issues. Justice Y.B. Chandrachud, who led this bench, he came under a lot of attack. And he also spoke out. He spoke out and he said, the court has the right to analyze any personal laws, and analysis is no sacrilege, because he was accused of sacrilege, because the Muslim clergy had got very angry at that time, and as they saw Rajiv Gandhi getting more and more defensive and acting against his instinct, because he spoke to people and said, look, I look at liberal women of my own party who come and say one thing to me, who whisper one thing to me, but when they go outside, they say something else. So they saw Rajiv Gandhi weakening, so the clergy got more aggressive and more demanding. And that's where the judiciary also came under pressure. So I told you what Justice Y.B. Chandrachud said. Justice M.H. Beg, who was then heading the Minorities Commission, former judge of the Supreme Court of India, he spoke up in defense of higher judiciary. He said that among the Muslim community, these are printed quotes, among the Muslim community, thinking process is suspended once it comes to three things: Aligarh Muslim University, Urdu, and Muslim personal law. And then he goes on to say that the court interpreting or analyzing any religion's personal law is not sacrilege. So that backing came from him also. So one more liberal Muslim voice, which at that point, unfortunately, did not count for very much. There was also Zoya Hassan, then a reader at JNU, and she said, every law needs to keep pace with the times, and this applies even more to something like Muslim personal law, which to begin with was rather liberal for its times. The Prophet was extremely conscious of the need to uplift women. Again, all of these voices were ignored at that point. Now there is a further complexity to this, for which we may not have the time today. Maybe we'll visit it at some other point of time. But when the British took over the government from the Mughal rule, a lot of the personal laws carried on, a lot of the faiths, a lot of the religions carried on in their own ways. So Hinduism went through their own reform. There was Raja Ram Mohan Roy, Mahatma Gandhi himself. The Muslims, on the other hand, wanted a law of their own. It is in that discussion very often British era judges called in the Qazi to the court and took the Qazi's advice and also drafting their judgments, etc. when it came to issues of Muslim personal law. But in 1937, the British passed Muslim Personal Law Sharia Application Act, and 2 years later, in 1939, they passed the Dissolution of Marriage Act, right? So that gave a separate, distinct dispensation to Muslim marriage and divorce. And those have been the issues of contention in Indian politics, law, and religious debate as well. I mean, just as an aside, the Pakistanis changed a lot of it. In 1961, under a martial law administration, they came up with an ordinance called Muslim Family Laws Ordinance, which actually set aside the idea of triple talaq or instant talaq, also polygamy, etc. At least made it very, very, very difficult. In fact, it's just an aside, but Pakistan dealt with this very differently, with this legacy of British times very differently. In 1961, both of these British era laws were gone in Pakistan. Under Field Marshal Ayub Khan's martial law administration, they passed an ordinance called Muslim Family Laws Ordinance, which set aside instant triple talaq as well as polygamy. So to that extent, the Pakistanis reformed their Muslim personal laws much earlier and even subsequently, although they've had many fundamentalist regimes. Ziaul Haq's regime, for example, Ziaul Haq promised Nizam-e-Mustafa, but even then the basic covenants of this reformist law or this set of reformist laws have not been reversed.